Hello, I'm Jubin Dana with Dana Legal Services, and in today's video we're going to talk specifically about how to get around a patent. A lot of our clients ask us, hey, I found this patent, it looks a lot like my product, how do I avoid infringing the patent? How do I get around it? How do I work around this patent? So there are three things that you definitely must avoid when it comes to other people's patents. Number one, which it sounds silly, but I'm going to tell you anyway. Number one is don't bury your head in the sand and avoid it. Don't ignore it. If you know about it, look into it. So number one, don't ignore it if you're aware of it. Number two, don't make the mistake of thinking that because yours looks different or has a different thing in it than theirs, that you're not infringing. That's a big mistake. Because under patent law, when you look at certain language, and of course what I'm talking about specifically is the language of the claim in the patent. And by the way, there is a big difference between an issued patent and a published patent application. How can you tell the difference? A published patent application typically starts with four numbers that are the year. So like 2019 or 2021. That is a published application. That is not an issued patent, therefore there are no rights associated with it at that time. On the other hand, an issued patent is something that has a number at the top that is in the millions, like 5 million is from the 90s, 6 million, 7 million, 8 million. Currently, as of November of 2021, we're at around 11 million. So the number starts with 11 and then some number after it. So where were we? We were talking specifically about looking at the claims of the patent to decide whether or not you're infringing. And here's the point. That claim language can be interpreted in two different ways. One way is the actual physical thing it's talking about, the other being the function or the thing that it does. So if we're talking about a device that sends a signal, we're talking about something that has a transmitter in it, and its function is to send information. So don't be fooled that because your thing doesn't have a transmitter, it has something that is not called a transmitter, it's called a transceiver. Well, you still are doing the same thing because a transceiver is a transmitter and a receiver combined into one. Bottom line, what I'm saying is the claim language not only has to describe what is happening, but it will also be describing some functionality that goes with it. So things that are equivalent to it could also be considered infringing. And that's where you have to be careful. You can't just say that because the claim said zipper and I use Velcro, that those are two very different things. However, functionally, they may be similar enough where it might be considered the equivalent. Now, that's all facts. It's got to be looked at in detail and analyzed. But the point I'm making is don't just assume that because there's a word in the claim that doesn't match up to something in your product that you're not infringing. So number one, remember what I told you, don't be silly. If you're aware of something, don't bury your head in the sand, ignore it until someone comes after you. Actually look into it. Number two, when you do look into it, don't make the mistake of thinking, hey, this is a different word being used in the claim than the word I'm describing to use my product. And number three, which may or may not be important, is whether or not the entity that owns that patent is an entity that really focuses on a specific, very narrow field of technology, or whether they have a lot of other things in different areas of technology. So someone may be a specialist at only building transmissions and that's all they do, and that's what they patent. Someone may be a specialist in building the whole car. So they will have technology around all kinds of other things. So how do I avoid patent infringement of a particular patent? Is I'm very focused on what that particular patent is talking about in terms of industry. Is it broad enough to cover multiple industries, or is it so narrow that it only covers one industry? And that's what I focus my attention on. Three things, like I said, don't be silly. Don't assume that different language means that you're clear. And three, take a very careful look at what area of technology the patent holder is in. I'm Jubin with Dana Legal Services. We'd be happy to have a consult with you to understand your fact pattern, to then explain to you your options, your costs, and what your next steps are, especially when it comes to looking at patents to determine whether or not there's any infringement issues or how you can work around them. Here's our contact info. Look forward to talking with you. Take care.